ourselves as well.
Yes,
Yeah, that's fine. I think Justice Goldlist is the Chief Justice for this round, I believe.
that's correct.
Thank you. Good morning, everyone. Are we ready to start? Yes. Okay. Collins, please proceed.
Thank you, Justices. My name is Navya Sheth, and I'm here with my colleague, Leisha Shah, on behalf of the appellant, Her Majesty the Queen in right of British Columbia in the case at bar. It is the appellant's position that the Supreme Court of Canada erred in finding that Mr. Desautel is a member of the Aboriginal peoples of Canada who can claim a right to hunt under Section 35 of the Constitution Act of 1982. We posit that the core issue in the case at bar is the meaning of reconciliation in relation to Section 35. True reconciliation requires that Indigenous and non-Indigenous members of Canadian society be equal partners in the creation of a new merged sovereignty. And to that end, the appellant has two submissions to make today. Our first submission, which I will address, is that a purposive interpretation of Section 35 extends protection only to those Aboriginal peoples who are located in Canada. Our second submission, which my colleague will address, is that even should this court find that the Lakes Tribe is a member of the Aboriginal peoples of Canada, there is still insufficient evidence to establish that Mr. Desautel has a right to hunt. Would the court require a brief summary of the facts?
No, thank you.
In light of these two submissions, we respectfully request that the Supreme Court of Lions Cup allow this appeal, uphold the relevant provisions of the Wildlife Act, that is 11.1 and 47A, as they pertain to the respondent, enter a verdict of guilty, and remit the matter to trial court for sentencing. To begin with the first submission, the majority in the dissent at the Supreme Court of Canada agreed that there is a separate threshold question of whether Mr. Desautel is a member of the Aboriginal peoples of Canada, which must be answered before the court can proceed to the Vanderpeet analysis. It is our position that this threshold question must be answered in the negative on a purposive interpretation of Section 35 that considers all three of the relevant contexts. In the 1985 case of the Queen and Big M Drug Mart, the court laid out the three contexts in which we are obliged to place constitutional provisions. They are the linguistic, philosophic, and historical context. It is our position that the majority of the Supreme Court of Canada erred in not conducting this three-pronged contextual analysis in determining the purpose of Section 35, and thereby overshot its purpose in their definition of the provision. To begin with the linguistic analysis of the provision, Karen and Alberta in 2015 tells us that constitutional interpretation must begin with the language of the provision in question, and that a constitutional interpretation must afford primacy to the written text of the Constitution. The written text of the provision in this case includes the words of Canada, which in the case at bar are a geographical qualifier, which places a limit on who may be considered a member of the Aboriginal peoples of Canada. The words of Canada are used consistently throughout the Constitution as a geographical modifier, including citizens of Canada and government of Canada. The presumption.
Sorry,
Go ahead.
please go ahead.
Justice.
No, I was just going to say, just a point of clarification. So you started your submission by saying located in Canada, and you re-emphasize that now by saying it should be a geographical scope. So my question to you, just for clarification, is if there was a Canadian who was abroad, right, and they lived abroad, would the approach for the government be that, oh, they're not located in Canada or they're not here, and so we're not responsible for them? And before you tell me that he's not a citizen and whatever, the point is that those are the modern governmental constructs. And so to the extent that you can tie his Aboriginal ties, then regardless, we should have a sense of responsibility for them, no?
I understand your hypothetical, Justice, and if I could address it in two parts, because I think there's two dimensions to it. Firstly, the question of a citizen being abroad in Canada, the presumption of extraterritoriality suggests that we can't apply Canadian law extraterritorially. So as long as that citizen continues to remain outside of Canada, we can't impose any law on them. But should that citizen return to Canada, they still become a member of Canadian society. And it is our position that is the bar, that it could be a citizenship requirement, it could be a residency requirement, but both of those two things are indicative of a broader level of participation in Canadian society that is necessary under Section 35 to be of Canada. Does that, and the presumption against tautology means that the provision cannot be interpreted in such a way that the words of Canada are rendered meaningless. And it is our position that interpreting them in a way that ignores the existence of the national boundary that forms our country would be to reduce them to essentially redundancy. And this
Okay, so Counsel, I have a question. So are you suggesting then, because you were just speaking about citizenship and permanent residency being qualifiers in some of the rights, there's no such qualification in 35. So your own argument that the words have to have meaning indicates that of Canada has a different meaning than citizen or permanent resident, because I think you're aware that there are rights in the Charter that are for citizens only, or citizens and permanent residents, and sometimes everyone. So I guess my concern is when we say of Canada, how do we exclude groups that were part of what would be modern day Canada pre-contact?
So Justice, I think the idea of citizenship or permanent residency is not exclusive. I think I may have misspoken. When I say residency requirement, we're referring to being located in Canada and thereby being a participant in society. And we're not looking to restrict that. And I don't think that the drafters of the Constitution were looking to restrict that either. However, if we do look at their intent by turning to the historical context, which I will do now, we can see that the minutes suggest the drafters of the Constitution as well intended the words of Canada to have a geographic limitation because they use the words of Canada, in Canada, and Canadian interchangeably in the drafting of that Constitution. And all three of those are synonymous with geographic qualification. And it's not just the members of Parliament, justices, that refer to it in this way. In fact, Aboriginal representatives present at the drafting of the Constitution, including Nellie Carlson, the Western Vice President of Indian Rights for Indian Women, stated that her definition of an Indian across Canada, quote, is someone who had been born and raised in this country and lived through the hardships. It's clear that in the minds at the time of drafting, there was clearly an intention to limit it to those peoples who are part of Canadian society. And it is our position that—
Counsel, I'm going to interrupt you for a second. How do you reconcile that notion with the trial judge's finding that the Sinuit people were forcibly removed from the lands? They did not go voluntarily. And so when we place the historical context of their move into some of the policy considerations that we are grappling with today in 2021, how can you possibly suggest that this group of people is not entitled to the benefits of what they would have enjoyed had they not been forced off their own land?
Justice, we acknowledge the historical injustices that arose as a result of colonization, but unfortunately, the law is limited by the scope of power afforded to the Canadian government by that provision.
Well, it's not limited, actually. You've had 3 levels of court suggest that your argument fails, right? You'd agree with that?
Yes, Justice.
Okay, so building on that foundation, how can you possibly suggest that what is your 4th level of government, or sorry, 4th level of court that you're making this argument for, should find differently than the 3 courts below, including the trial judge who found that the move itself was involuntary?
Respectfully, Justice, we're not disagreeing with the finding of facts at the level of the trial judge, but it is our position that the Supreme Court of Canada, in addition to the lower courts, overlooked the development of jurisprudence in this area that inspires the philosophic context. And if we look to that jurisprudence in 2010, in the case of Beckman and Little Salmon Carmacks First Nation, the Supreme Court of Canada did find that the grand purpose of Section 35 was the reconciliation of Aboriginal and non-Aboriginal Canadians in a mutually respectful long-term relationship. And it is this relationship looking forward that the Honor of the Crown aims to build. And unfortunately, Justice, the precedents of the Supreme Court of Canada indeed do acknowledge at several places, including in the Queen and Vanderpeet and Mitchell and MNR, that Section 35 rights are rights afforded to, in Mitchell, quote, 21st century rights exercised as group rights by modern Canadians. And therefore the conception of the Supreme Court of Canada historically with respect to Section 35 has been to limit its exercise to those peoples who are part of Canadian society and qualify as Canadians.
I'm sorry, Counsel. I'm gonna reiterate some of the things that my fellow justices have said. This, to me, just sounds like a consistent, perpetuating, notion of using this feeble argument of artificial international borders to say I can't look into what is deserved or what rights Aboriginal peoples have. Can you move past this geological argument? I'm trying to understand how we can't recognize in this idea of reconciliation that there were a group of people, Indigenous people, who lived on this land and were forcibly removed, as my sister Justice had mentioned. Are we just to simply ignore this and say, now there are borders, we can't do anything about it? Sorry, that doesn't seem in line with your proposed approach in regards to reconciliation.
Justice, there are, as have been acknowledged at the lower courts, other options such as a common law right that may be available to Mr. Desautel. However, those issues were not advanced at trial or at the level of the Supreme Court of Canada. And the question before this court is whether the border can constitute a limitation on Section 35. And if we turn to the case of the Queen and Vanderpeet, at paragraph 49, it does say that in pursuit of reconciliation, the courts must take into account the Aboriginal perspective, but do so in terms which are cognizable to the non-Aboriginal legal system and to our constitutional structure. And it is our position that to ignore the existence of international borders, which are the very foundation of a country's sovereignty, would be to act in a way that is not cognizable to the non-Aboriginal legal system and constitutional structure. Because, Justice, at the end of the day, the Queen and Gladstone also found that because distinctive Aboriginal societies exist within and are part of a broader social, political, and economic community, limits placed on Aboriginal rights are equally a necessary part of reconciliation. In this conception, barring any further questions, this concludes the first submission on behalf of the appellant. My colleague will now proceed with the second submission. Thank you, Justices.
May I proceed? Good morning, Justices. My name is Laisha Shah, and I will be concluding the final submission on behalf of the appellant, Her Majesty the Queen in right of British Columbia in the case at bar. It is our position that the majority erred in their application of the Vanderpeet test. The test comes from the 1996 Supreme Court of Canada decision of the Crown and Vanderpeet. There are 3 stages to this test. The first stage is to characterize the right claimed in light of the pleadings and evidence. The second stage is to determine whether the right is integral to the distinctive culture, and the final stage is whether the modern right is a continuation of an ancient right. We are concerned with the final 2 stages of the test. We take the position that there has been a legal error in the application of facts, and the evidence presented by the majority is insufficient to meet the test. The majority stated that the connection to the land was still present in the minds of the members of the Lakes tribe. However, this is not sufficient to constitute as evidence of continuity and is not evidence that is properly cognizable by the courts. Further, the majority also presents the practice of hunting in Washington. However, this is once again not sufficient. While hunting for ceremonial purposes is integral to the distinctive culture of the Sinaites, the lower courts fail to acknowledge the body of jurisprudence of the Supreme Court of Canada, which interprets the Vanderpeet test as a right to hunt is site-specific, and on a particular tract of land, bearing a geographical limitation on hunting rights, and is not an abstract right exercisable anywhere. The majority, in assessing the integrality of this practice.
So I'm going to put a similar question to what we put to your colleague, I think. or perhaps not yet, but I would like to know at what point, like what sort of evidence would you require of this being a continuing right? You're saying the evidence isn't sufficient. What would be sufficient and why isn't this? I mean, we're hearing how, the trial judge did find that there was a connection to a tribe that is now extinct in British Columbia, but that there were in fact traditional hunting rights. And now we have an international border. So in order to maintain the continuity of their rights, they would have to cross an international border and break the law in order to continue with their traditional hunting. So how do you propose this evidence would have been found, given the fact they would have had to break the law to continue their hunting past the 1930s?
Justice, I would like to answer your question in two parts. First, the jurisprudence of the Supreme Court of Canada upholds a site-specific requirement for a right to hunt, and more particularly for any right that is intrinsically linked to a particular tract of land, such as in the case at bar. And so what we would look for continuity as well as integrality is that the Sinaiaks or the Lakes tribe practice on their ancestral territory, which is now in BC, to fulfill these requirements. And there should be a reasonable degree of continuity. And respectfully, justices, we do not coincide with the majority assertion that 80 years is a reasonable temporal gap to find continuity.
Counsel, I have a problem here with how we are looking at the scope that we're using to look at this continuity. Are we looking at the elements, the evidence in question? Are we looking at it in a way whereby we're ascribing onto Indigenous peoples our way of understanding what continuity looks like? Or are we going to stop this colonial settler mentality and start to recognize that continuity can be defined in a different way, and that we should recognize how Indigenous peoples themselves interact with one another and how they seem and they perceive continuity, especially considering they were not able to come back due to international borders. So there's only a limited scope in which they could continue to have a connection to the land despite these international borders. And so I want to know, are we going to look at it from our perspective, this colonial perspective, that you must have been there or had some physical, tangible connection? Or are we going to look at it from their perspective, which is, from what I recognize in the case law, in the case at bar, an oral history, that they used to have circles and gatherings where they would conduct stories and talk with one another about how they were connected to the land? Does that not constitute evidence as well?
Justice, we do not agree that that would constitute as evidence of hunting in Washington. And I would like to address your concerns in 4 parts. And while we acknowledge the injustices faced by the Indigenous peoples, the Crown has a responsibility to Canadian Indigenous groups residing within Canada. And in fact, in the case of Cote, the Supreme Court of Canada explicitly considered the effects of colonialism. And yet in a unanimous—
Okay, I'm gonna stop you there, because these are ancestors of an extinct group. So these are descendants of an extinct group from British Columbia. So again, I come back to my original question, which is, how could we have expected them to maintain continuity when they would have been forced to break the law to do so, in coming up and hunting without a license, which is the charge Mr. Desautel has been charged with. So we put up these barriers, and yet we still expect them to show continuity. How do we square that? As one of my co-justices indicated, how do we square that with the fact that we're supposed to move away from colonialism and settler mentality?
Justice, I would like to answer your question in 2 parts. First, we recognize that the imposition of the border can very well be a barrier to the Indigenous peoples traveling to their ancestral territory to hunt. However, the reality of the matter is that after the imposition of the border in 1846, the Lakes tribe still traveled up to their ancestral territory, which is now in BC, until 1930. And further, the Wildlife Act did not bar this practice until 1996. However, they did not practice between the years of 1930 and 1996. And so we do not posit that this temporal gap is reasonable by any means, in accordance with the jurisprudence of the Supreme Court of Canada.
Sorry, I don't understand. You're suggesting that the border that was imposed upon these people should be sort of a false gap for us, allowing them to have the constitutional rights that that the respondents claim they have and the 3 levels of court have claimed they've had, and yet you want us to show some sort of evidence beyond that imposed territorial gap with which they should satisfy? I don't understand. Your argument's a little bit circular, is it not?
Justice, we'd like to push back against that characterization. While the Indigenous peoples did face barriers, and we are deeply sympathetic to these barriers, we have to acknowledge that there is good reason for this court, as the courts before this in other various numerous cases, uphold the site-specific requirement. Because in this case, Mr. Desautel is asking for a site-specific right to hunt and not a generalized right to hunt. And so geography is clearly a relevant factor. And even if the court did not coincide with these findings, there are deleterious implications to such a finding that groups—
Like what are the deleterious results that you think should now put some sort of a stopgap into this reconciliation that the 3 lower courts below us have attempted to resolve?
Justice, such a finding that groups can claim right to lands which they do not reside within and do not actively practice on could very well dilute the already limited Aboriginal groups residing within Canada possess. This could result in tensions between groups on either side of the 49th parallel. And this is not merely a hypothetical.
I'm sorry, and where's the evidence of that?
As stated in the trial judge's reasonings at paragraph 99, there are numerous documented instances of tension. And so geography is clearly a relevant factor. And in fact, we posit an important one. Now, our friends may submit that the Vanderpeet test does not outline such a requirement. However, general trading rights lack an inherent connection to a specific tract of land. Thus, geography was not a relevant factor in the in the Aboriginal rights trilogy of Vanderpeet, which was involving claimed right of exchange or trade, which fall on the opposite end of the spectrum to a site-specific right, such as hunting. Ultimately, the characterization of the claimed right in the case at bar, as in Adams and Cote, imports a necessary geographical element. Respectfully, justices, if hunting—
So I'm going to put this question to you very, very simply. I want you to put yourself in the shoes of Mr. Desautel. And I want you to explain to me how your people are to express continuity in light of there being an international border that has been imposed upon you by the very sovereign that is not giving you these rights. I want to understand how you would overcome that.
Justices, there are other ways to address this concern, such as a citizenship requirement, applying for permanent residency. However, as I've submitted for the court, the imposition of the international border until 1930 did not stop the Lakes tribe from traveling up to their ancestral territory in BC. Mr. Desautel is asking for a right to hunt for ceremonial purposes. That right is traveling up to what is now BC from Washington to conduct their seasonal hunting round. That is what is being asked in this case. And that involves a particular tract of land across an international border. We acknowledge this. However, this has not been fulfilled, and presently, as established in the case at bar, they have not conducted this seasonal hunting round in quite some time. And so continuity is not met. An 80-year temporal gap would not fulfill the last 2 requirements of the Vanderpeet test. And there are good reasons for—
But it's again, it's an 80-year temporal gap that is not of their making. So that's the concern. We have lower courts who have decided that this is okay and that the 80-year gap is not significant. We're talking about thousands of years potentially. So I agree with my co-justice that your argument is becoming a little bit circular. I'm wondering again how we square that with what we are expected to do by the Constitution and support reconciliation.
Justices, reconciliation is between members of Canadian society and Aboriginal peoples within Canada. And so this would do little in advancing reconciliation. And so
you don't think the Canadian government owes a bigger debt to Aboriginal peoples than just those who currently qualify as Canadian citizens, such as those who were forced off their land?
Absolutely, Justice. However, oh, I see my time has nearly elapsed. May I briefly answer your question?
Please.
Thank you. Justices, there is good reason. There's good reason for the province to prefer the rights of its own residents, especially Indigenous groups, to hunt in BC. In allocating wildlife resources, the Crown must give top priority to constitutionally protected Aboriginal rights. Those who are indisputably holders of constitutionally entrenched Aboriginal rights should not be concerned that their rights will be inappropriately diminished. And so we implore this court to allow this appeal. Thank you.
Chief Justice, I seek your permission to time myself.
Sure.
Thank you. Good afternoon, Justices of the Court. My name is Manga, initial S, and my co-counsel, Mataru, initial R, rise on behalf of the respondent, Mr. Desautel, in the case at bar. Before we begin, my co-counsel and I wish to acknowledge the land upon which we both operate. The region of Peel is the traditional territory of the Anishinaabek, Huron-Wendat, and the Haudenosaunee. We are very grateful to these Indigenous tribes for taking care of this land. I will now proceed with our submissions. We are requesting the Supreme Court of Lions Cup to deny the appeal and answer the test question in the affirmative, and we will be presenting 3 submissions before the court today. First, I will submit that an Aboriginal collective located outside of Canada does fit within the scope of Aboriginal peoples of Canada. Then, my co-counsel will submit that a member of an Aboriginal collective located outside of Canada can claim the constitutional protections of Section 35, since Mr. Desautel does meet the Vanderpeet test requirements, specifically the continuity element. And finally, my co-counsel will discuss the policy implications of this test case. Drawing your attention to our first submission, Justices, Section 35(1) of the Constitution Act states that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. However, the text does not provide much guidance in addressing the threshold question in the case at bar, which is whether an Aboriginal collective located outside of Canada falls within the scope of Aboriginal peoples of Canada. Although our friends have submitted the words of Canada imports a geographic qualifier, however, those same words of Canada are capable of different meanings, since the word of can also be used to describe a range of relationships. Hence, we cannot rely solely on a linguistic textual interpretation as part of the purposive interpretation. And in order to define Aboriginal peoples of Canada, we must conduct a purposive interpretation of Section 35 that furthers the objective of reconciliation, as mentioned in Sparrow at page 1106. And we will be doing this today by assessing the court's jurisprudence and the trial judge's findings. Justices, when we consider the court's jurisprudence, there are two
I'm going to tell you where my mind is right now. I'm
Yes,
kind of
Justice.
interested in hearing a little bit about how you would answer your friend for the appellant's concerns that this would cause conflict or could derogate from the rights of Canada's current Indigenous people, those that currently reside here. I'm wondering if you could speak to that a little bit.
Certainly, Justice. It is our position, or the respondent's position, that Aboriginal peoples of Canada, or the definition of that, is that the Aboriginal peoples of Canada are modern-day successors of Aboriginal societies that resided in Canada at the time of European contact. And so when we touch on that in terms of the trial judge's findings, the trial judge did find that in 1811, which is the time of contact, the Sinixt peoples were present in their traditional territory in what is present day BC. And she also found that the Lakes tribe are a modern successor to the Sinixt. So when we consider this and the definition of Aboriginal peoples of Canada, it really, we're trying to establish that the Lakes tribe are Aboriginal peoples of Canada, and there wouldn't be a detriment as to what our friends have submitted.
I have a question, Counsel. I know you're going to get into the common law and the jurisprudence, but your friends have submitted that this integral component of legislation, which is the legislator's intent, and they've submitted meeting minutes to describe that intent that the legislators had in mind, and to that effect state that, and pulled on that and stated that the intent was for Canadians, specifically Aboriginal peoples who are within the geographical boundaries of Canada. Can you please speak to that?
Yes, Justice, certainly. So my answer to that would be a two-part. First one, although our friends did submit that the constitutional minutes of proceedings offer no evidence about the protections of Section 35 being offered to an Aboriginal collective located outside of Canada, those same minutes do not offer any evidence about the protection being offered to Aboriginal peoples located inside Canada. Their intentions are not explicitly stated in the constitutional minutes that our friends have brought forward, which is why we have to rely on a stronger record of evidence. And that's why I turn your attention towards the trial judge's evidence. And briefly, what was the second part of your question? Or second part of that was yes, and also I believe you did ask about, or our friends did submit that Aboriginal representatives were present at those meetings, and they did give their definition of what Aboriginal peoples of Canada are. However, in 1982, there was no case brought about whether an Aboriginal collective outside of Canada was trying to claim a constitutional protection in Canada, which is why this is a test case, and which is why we submit that Lakes tribe are Aboriginal peoples of Canada, and we have to reconcile their modern day existence with the Crown's sovereignty. So when we consider the two underlying purposes of Section 35, these two are first, to recognize the prior occupation of Canada by organized autonomous societies, and second, to reconcile their modern day existence with the Crown's assertion of sovereignty over them. And these two purposes were explicitly brought out in the Vanderpeet case. Specifically at paragraph 31, Justice Lamer observed that when Europeans arrived in North America, Aboriginal peoples were already here. He noted that the constitutional framework through which the fact that Aboriginals lived on the land in distinctive societies with their own practices, traditions, and culture is acknowledged and reconciled with the sovereignty of the Crown. Another example of this can also be found in the Manitoba Métis Federation Inc. case at paragraph 67, where Justice McLaughlin noted that the honor of the Crown recognizes the impact of the superimposition of European laws and customs on the pre-existing Aboriginal societies. The honor of the Crown characterizes the special relationship that arises out of this colonial practice. In other words, because the Crown asserted sovereignty over Canadian land, the Aboriginal peoples, which were already here, they became subject to a legal system they did not share in a language that was not familiar to them. Hence, the Crown has a fiduciary duty to treat Aboriginal peoples fairly, honorably, and to protect them from exploitation.
Yeah, we understand they have a fiduciary duty and that they've somewhat failed in that. The concern, I guess, that's coming to my mind is if this court agrees and upholds the lower court's decision, are we not potentially opening a floodgate to claims from south of the border? Because there will be ancestral connections between many of the bands on our side of the border and on the American side of the border. So how would we address that?
Yes, Justice. We do agree that this is a test case and it can set precedents for future cases in the court. However, cross-border tribes would have to go through the similar process that Mr. Desautel is going through in the case at bar to establish their Aboriginal right, whether it's an Aboriginal right to hunt for ceremonial purposes, whether it is an Aboriginal title, a claim for Aboriginal title. So they would have to still go through that process and meet the requirements of, in the case at bar specifically, the Vanderpeet test requirements before they can establish they have an Aboriginal right protected under Section 35 of the Constitution. So there are checks and balances in place to recognize that as well.
Okay,
Now,
checks and balances that sound expensive. Because if everybody has to go to court to prove a right, we're now depleting resources that could perhaps have been expended in support of the Indigenous persons that are already here. So again, it comes back to is the fact that there's going to have to be an individual claim. If there is an individual claim for each of these individual claims that come from south of the border, we still have to fund that fight through our court system and through our tax dollars. So again, the concern is still, are we going to potentially be looking at a flood of these cases and an expenditure of Canadian government funds?
Yes, Justice. This is a hypothetical, like we cannot anticipate the number of cases that would be brought about, or like the number of claims that would be brought about by cross-border tribes. However, if we consider that Aboriginal peoples historically have faced so many injustices, there has been a lot of times where Canadian sovereignty has been elevated above Aboriginal sovereignty. This is a pivotal moment in this test case that where we can take a positive step towards that reconciliation, towards achieving a balance between Aboriginal rights and Canadian sovereignty. And in the case at bar, it is our position that in order to do that, in order to engage in that process of reconciliation, we would have to elevate Aboriginal sovereignty above Canadian sovereignty to take that positive step towards reconciliation.
So while recognizing the adverse effects and injustices of colonialism along the years, where we stand today and what your friends have submitted is that we need to focus on reconciliation between the Crown, between the Canadian society and Aboriginal peoples of Canada today. So don't you think that by setting or placing a high burden with regards to issues of the borders, of duty to consult and accommodate, we are compromising the Crown's ability to be able to achieve that reconciliation?
Justice, I have a two-part answer to your question. The first is the honor of the Crown. Like whenever a claim is brought about, the burden has to be on the Crown, because the Crown did assert sovereignty over Canadian land, and Aboriginal peoples became subject to that. And second is that it is our submission that the Lakes Tribe are Aboriginal peoples of Canada. So it is in the honor of the Crown to reconcile with the Lakes Tribe that are Aboriginal peoples of Canada, and the Lakes Tribe will continue the Sinaiaks people's legacy through them. The Sinaiaks are not extinct, contrary to the Extinction Declaration in 1956, and it is our position that the communal rights of the Lakes Tribe, rights of the Sinaiaks continue with the Lakes Tribe, as they are considered Aboriginal peoples of Canada. Pending any further questions, my co-counsel will now address our second and third submissions. Thank you.
Hello, Justices. Please let me know when I should proceed.
Please proceed.
Perfect, thank you. My name is Matthew, initial R, and today we'll be submitting that a member of an Aboriginal collective can claim the constitutional provisions of Section 35(1), and that Mr. Desautel does meet the Vanderpeet requirements, specifically the continuity element, and we will be discussing further policy implications. Before I draw you into my submission, I would like to further address the policy implications mentioned by my friends and discussed by the justices previously with my co-counsel. duty to consult. In paragraph 75, it states that there is no freestanding duty on the Crown to seek out for Aboriginal groups, as it is the group who puts the notice of that claim. And to further continue this, in Powley, it mentions in paragraph 49 that the difficulty of identifying members of the Aboriginal community must not be exaggerated on a basis for defeating their rights under the Constitution of Canada, meaning we must recognize their rights. It doesn't matter how many groups there were because they were prior occupants and they still have those rights in place.
Counsel, are you citing the very case that stands in the face of Vanderpeet, the other case that you're also relying on? Are you being very selective with what you're choosing to extract from these cases?
Sorry, Justice, could you rephrase that question?
So you cited the case of Polly, is that correct?
Yes, I did.
Okay, and from my understanding, the case of Polly is in direct contradiction to the case of Vanderpeet. So what I want to understand is, are you selectively choosing what to present to the court as a basis for your evidence?
No, Justice, we are not selectively choosing cases. And the duty to consult is not a concern because it is the responsibility of that group to bring notice of that claim. So that was just another point taken from the dissenting to support that claim that I had made earlier.
So you can see that your point comes from the dissent of Polly. The point that you're making comes from the dissenting opinion in the case of Polly. I'm just asking
No,
that.
it does not. It does not. It comes from the majority of Powley. Sorry, that was my misinterpretation.
Okay.
Apologies. Drawing your attention to our first submission. To begin, I will be analyzing the Vanderpeet test. This test is referred to at paragraph 51 of the case. And for our purposes, we will only be analyzing the second and third prongs, as the first prong is not an issue at bar. First, we must determine whether the claimant has demonstrated that a relevant pre-contact practice, tradition, or custom existed and was integral to the distinctive culture. Then we must also determine whether that claimed modern right is demonstrably connected to and reasonably regarded as a continuation of that pre-contact practice. And to begin, Mr. Desautel is a modern-day successor of the Sinaiaks group. British Columbia is his ancestral territory, and activities such as hunting and fishing are traditions that are integral to that distinctive culture. The trial judge did not find that this move was voluntary, and though the respondent recognizes that there was a gap between 1980 to 2010 when no hunting or fishing took place, the connection... Yes.
Would you agree with a definition of integral as per Vanderpeet that would say that the practice is a crucial defining feature without which the culture would be fundamentally altered? Would you agree with that definition? Do you want me to repeat the definition?
Yes, please.
An integral practice is a practice that is crucial, that is a defining feature without which the culture would be fundamentally altered.
Yes, I agree with that. And
sorry, Counsel. So along the lines of that definition, if a practice is so integral, how would you justify or reconcile an 80-year gap? The one your friends talked about.
Respectfully, Justice, the timeline is not the issue here. It is the idea of that practice and that connection to that land. And Aboriginal communities were here before the borders. Aboriginal communities were here before the Constitution, before Section 35, and they have those rights.
But don't you think, and just sort of building on what Justice Fahmy was just asking you about, what about the notion of abandonment? Do you understand what I mean by that?
Yes, Justice. And to answer that question, I would like to go into the oral history that was provided by the Aboriginal community to prove the connection to that land as sufficient evidence.
You don't have to prove the connection to the land. We appreciate that there was a historical connection. What I'm asking you about, and what my sister Justice Fahmy just asked you about, which you haven't answered, is the notion of abandonment, such that this group has abandoned their rights when they left Canada, situated themselves south of the border, and have now spent 80 years hunting and fishing in a different territory. Why do you think that they now, 80 years later, have the right to resume these practices in Canada?
Yes, Justice. To answer that question, I'll be answering it in two parts. Firstly, Aboriginal communities have been here thousands of years, so that dormancy period of 80 years is not equivalent to the thousands of years that they were already prior occupants to this land. And secondly, to address that question, I want to prove how integral it was to them. And it was so integral to the Aboriginal community that even after the Game Amendment Act was implemented in 1896, which in Section 6, it states that it should be unlawful for Indians not residents of this province to hunt big game at any time of the year, they still continue to do so, even when it was illegal. And they did that.
You don't think they abandoned those rights for 80 years?
No, they did not abandon those rights. It is our duty to give them those rights. And they
Counsel, you just said that despite the creation of this law that banned them from being able to engage in this practice, that they'd still continue to come over and engage. And I think in the case at bar, I think it's paragraph 133 or 134, it mentions that they had continued to do this practice up until about the 1930s, despite the law taking effect in 1846. It's almost another 70 years that they completely ignored the law and continued to come in and take on their right, as you put it. So this dormancy is not as a result of geographical borders, but as my sister justices have put forth to the court and to yourself, it's more or less of their own accord. So how do you reconcile that?
Justice, respectfully, as the trial judge, should be given deference. And this abandonment is not an issue. It is their right, and they must be able to exercise that right whenever they choose to. We should be able to give them that right to do so.
But I think the point of abandonment, it's not it's not abandonment per se, right? Like the history is irrelevant, because I think the point of abandonment is not just that they abandoned it; it's the fact that they actively chose to situate themselves somewhere else, and that's not abandonment and then a reignition of trying to assume rights. It's you can't have it both ways, right? You can't have someone who then tries to situate themselves with new practices and 80 years worth, right? The history component as an answer becomes irrelevant, because it's no longer an absence of action. It's a divergent action towards a new practice.
Yes, Justice, and the trial judge did find that this move was not voluntary. She did also state that it was not at gunpoint, but we can at least acknowledge that
not the move, but to stay there and to continue the practice there. Right, the impetus that for them to have left is irrelevant without really analyzing what they did for those 80 years.
Yes, Justice, and for this we can only assume that it was the result of colonialism. It was the result of Europeans, as the trial judge found that it wasn't voluntary.
Okay, so it's the Europeans' fault, fine. So for 80 years, they sat and hunted in Washington and said it's the Europeans' fault, and now they're coming back and saying, for the first time, no, we want our rights back?
They have not lost their identity, Justice. They can choose to continue that practice as they please. That practice is integral to their distinctive culture, and it's a part of their identity. We are not at liberty to take that away from them.
That's what I'm saying. I guess if I could piggyback off my brother Justice's point here, let's say we give you the argument that it is integral. And let's say that we give you the argument that they had continued to pursue this practice as being integral to the Aboriginal peoples of the Sinks. My question is, you're really putting forth to this court that the continuity element has still been met, despite what your friends have submitted. And what I'm putting forth to you is, there is no, what's the word I'm looking for? There was no separation, or there is a separation due to the dormancy of this practice. And it's basically this underlying theme, I think, that's going on that you're telling me is it's the geographical borders that have really been this divide as to why they couldn't practice and engage in this practice. Whereas I'm trying to ask you, it's not the geographical borders, because they continued this practice for years after the laws had taken effect. So are you telling to the court today that the continuity portion has only been disrupted because of the sovereign of Canada's borders, or are you saying, no, we do concede that the Cynics people themselves, and Mr. Desautel as one of these people, gave in to this idea of dormancy, and they didn't need to pursue this after 1930, despite the fact that they had continued to go after hunting and so on and gathering after the law had taken effect? I know that's a very long-winded question. If you need me to reiterate, I can do my best.
To answer that question, I do want to rephrase and state that colonialism was a part of the 1800s, 1900s, and that's why we can only assume that Mr. Desautel or the Lakes tribe felt that they couldn't hunt, and that puts a burden on them. It is our responsibility as the crown, and to uphold the honor of the crown would mean to balance the probabilities, and to balance the probabilities would mean to elevate Aboriginal rights and elevate them and accept the evidence to connection of the land as oral histories, accept that Western traditions are different than Aboriginal traditions and customs, and that we must respect them and acknowledge them. I see that I am almost running out of time, as I would like to briefly conclude and leave you with this, that the appellant's remedy does not support reconciliation, as sending another Indigenous man through our justice system is not about reconciliation. There's already a small percentage population of Indigenous peoples and a large amount that are represented in our justice system. And the administration of justice would be in disrepute. Therefore, today we submit to the Supreme Court of Lions Cup to dismiss this appeal and allow the test question to be answered in the affirmative. If there are no further pending questions, this ends the respondent submission. Thank you.